The next item of business is a statement by Kenny MacAskill on Lockerbie. The Cabinet Secretary will take questions at the end of the statement, and there should therefore be no interruptions or interventions. I call on Kenny MacAskill, Cabinet Secretary. You have 10 minutes.
Presiding Officer, can I once again put on record my sympathy for the relatives of all those lost in the Lockerbie atrocity. Whether it's American and the many other nationalities murdered in the air, or Scots lost on the ground, the anguish remains with them constantly. However, I have been asked by the opposition to make a statement to Parliament in this matter once again, and I am willing to do so. Both myself and this government have always sought to be as open and transparent as we can be in all matters relating to Lockerbie. The need for this statement relates to claims made in a book written by a former researcher with Mr al-Megrahi's legal team. Presiding Officer, these claims are wrong. Minutes of meetings relating to Mr al-Megrahi were made at the time and have, except where permission was not given by other governments, been published. A minute of my meeting with Libyan representatives is one of them. Unlike the claims of recent days, these minutes are not hearsay, but an accurate record made at the time. This minute has been in the public domain since September 2009. It is quite clear and refutes the assertions made. These records are made by impartial civil servants to ensure that there is a proper historic record of important discussions. In addition to the minute kept, Presiding Officer, let me be quite clear. Scottish Government officials were present throughout my meeting with Mr al-Megrahi. At no time did I or any other member of the Scottish Government suggest to Mr al-Megrahi, to anyone connected with the Libyan Government, or indeed to Mr al-Megrahi himself, that abandoning his appeal against conviction would in any way aid or affect his application for compassionate release. Let us remember what the two different processes were. One process was an application under the prisoner transfer agreement made by the Gaddafi regime. This required an end to any appeal proceedings before a transfer could happen. The second process was an application for compassionate release made by Mr al-Megrahi himself, to which no such condition applied. We vigorously opposed the prisoner transfer agreement negotiated by the then UK government with the Gaddafi regime, not least because it represented interference in the Scottish legal process. We wrote to the UK government no fewer than 8 times between June 2007 and September 2008, setting out our position. I considered, but rejected, the application for prisoner transfer made in respect of him, and I granted a request for compassionate release submitted by him, as I believed it adhered to the laws and values we hold in Scotland. I did so on the evidence before me from the Parole Board, the Prison Governor and Director of Health and Care in the Scottish Prison Service. The Scottish Government had no interest whatsoever in Mr al-Megrahi's appeal being abandoned. I had no involvement in Mr al-Megrahi's decision to drop his appeal against conviction. That was entirely a matter for him and his legal team. However, Presiding Officer, one thing that is now clear from this new book, as detailed on page 352, is that Mr al-Megrahi signed a provisional undertaking to abandon his appeal on March 23, 2009. It's clear, therefore, he was considering dropping his appeal several months before either of the two applications were put before me. At the time, Mr al-Megrahi had no way of knowing what my decision would be, either on compassionate release or on PTA. However, he did know that a prisoner transfer application would have been refused had there been any ongoing legal proceedings. The author of the book, John Ashton, has himself accepted on BBC Radio yesterday that the claim in the book is hearsay. This government has shown consistently we want to be as open and transparent as we can be on all aspects surrounding the al-Megrahi case. That is why we've brought forward the Criminal Cases Punishment and Review Bill to aid publication of the Statement of Reasons. An assertion by the author is that we, the Scottish Government, do not want the Statement of Reasons published. Presiding Officer, nothing could be further from the truth. This legislation, introduced by this Scottish Government, will enable the Scottish Criminal Cases Review Commission to decide whether it is appropriate to disclose information in cases they have investigated where a subsequent appeal has been abandoned. The legislation helps leave the Commission as a decision-maker as to whether they publish their report on the al-Megrahi case. Under the legislation, the Commission have to decide whether, in the whole circumstances, it is appropriate to disclose their statement of reasons. There will be a range of factors the Commission will want to consider when deciding whether it is appropriate to disclose information. One key factor is likely to be how much of the statement of reasons is already in the public domain. With the publication of the book and television documentaries containing what apparently may well be significant material from the Statement of Reasons, this could be an important factor which the Commission may want to consider when they decide whether it is appropriate to disclose information they hold. As members know, we are limited within the powers of this Parliament as to how far our legislation can go in freeing up the Commission to disclose information. Data protection, which is a reserved matter, is a key obstacle to disclosure. I first spoke with Kenneth Clarke back in September 2010 on this issue, and since our bill was introduced, I've already written to him on 3 occasions on this issue. We are now faced with publication of material that is apparently from the Statement of Reasons. This means that the case for an exception to data protection rules is now overwhelming, but this is for the UK Government to act upon. That is why today I've written again to Kenneth Clarke, urging that the UK Government now make a decision for an exception to be made to the normal statutory data protection rules for this unique case. This will help ensure the wider public interest can be served and the road to publishing the Statement of Reasons is further cleared. Let no one be in any doubt. We want the Statement of Reasons published and are doing all that we can within the powers of this Parliament for it to happen. Mr al-Megrahi was convicted in a court, and that is the only place where his guilt or innocence should be determined. We recognise that some have concerns regarding the wider issues relating to the atrocity. The wide-ranging and international nature of the issues involved means that there is every likelihood of issues arising which are not devolved, which would require either a joint inquiry with or a separate inquiry by the UK Government. We remain ready to cooperate on an inquiry. Members will want to know whether there is a mechanism for an appeal still to be heard, even posthumously. Presiding Officer, I can confirm to the Chamber that there is. It would involve an application being made for a further reference by the SCCRC, the Commission deciding to make a reference, and for the High Court to accept such a reference. These, of course, are not matters for me as Justice Secretary to decide upon. These are decisions for others to make, but I think it's important that we as a Parliament are aware of the position. Presiding Officer, as I neither sought the abandonment nor continuation of Mr al-Megrahi's appeal, it is not for me to either seek or oppose a potential appeal, posthumous or otherwise. That is correctly a matter for others, and I would have every confidence in the Scottish criminal justice system were there to be another appeal. That is a matter I would be entirely comfortable with. We want the Commission's report to be in the public domain to help ensure public confidence is retained in our justice system. This government is doing all that we can to bring disclosure of the statement of reasons, and I urge all members to support these efforts by supporting our bill and supporting our efforts to get the UK government to make an exception to data protection rules.
The Cabinet Secretary will now take questions on the issues raised in his statement. I intend to allow around 20 minutes for questions, after which we'll move on to the next item of business. It would be helpful if members who wish to ask a question were to press the request to speak button now. I call Lewis MacDonald.
Thank you very much, Presiding Officer, and can I thank the Cabinet Secretary for an advance copy of his statement, and indeed can I welcome his decision to come here and make a statement on this matter today. We are here because of the connections between decisions that were made in August 2009, first by Abdelbaset al-Megrahi and secondly by the Cabinet Secretary. Mr al-Megrahi's decision was that he should withdraw his appeal against the conviction for the worst mass murder in Scottish legal history. Mr MacAskill's decision was to let that man go on the grounds that he had only a few months to live. But we are here today because that very man, whom he released on those grounds, has now asserted 2.5 years later that he dropped his appeal because the Cabinet Secretary had used a third party to encourage him to do so. And we have heard the Cabinet Secretary confirm today that he did indeed meet that third party, Mr al-Megrahi, a minister in Colonel Gaddafi's government, and drawn our attention to the minutes of that meeting and of the meeting he had with Mr Megahi in Greenock Prison. Those do make very interesting readings, because at both meetings, Presiding Officer, time and again, Mr MacAskill and his officials stressed that release under a prisoner transfer agreement could only proceed if Mr Megahi dropped his appeal. At no time, it would appear from these minutes, did Mr MacAskill make the point he has made today and repeatedly over the last 2 years, namely that his decision to release Mr Megahi had nothing to do with the prisoner transfer agreement, or that compassionate release would not require that Mr Megahi drop his appeal. Those are the words of the minutes of the meeting. And when Mr Salmond suggests from a sedentary position that that is a misrepresentation, is he telling us that these minutes are not a full and accurate record of the meetings that were held? Because if they are a full and accurate record, then I would like to hear the Cabinet Secretary's comments. Does he now accept that his conversations with both Mr al-Megrahi and Mr al-Megrahi did indeed leave both men with the very clear impression that withdrawing the appeal was the prudent thing to do? And does he now regret either of those meetings or the way in which he handled them?
Cabinet Secretary.
No. Mr MacDonald is quite right. There were two separate meetings. There was a meeting with Mr al-Megrahi in Greenock, in which he was supported and represented by his lawyer, a member known probably more closely to some of Mr MacDonald's colleagues than I. He was present throughout. At that stage, there had been no application for compassionate release submitted, and the discussion was simply on the question of prisoner transfer agreement. The meeting with Mr al-Megrahi again touched upon both matters, but I can be quite clear. It was never suggested to Mr al-Megrahi directly, or indeed to a third party, that the appeal required to be dropped. It was simply made quite clear that the terms of the prisoner transfer agreement entered into by a Labour government south of the border with Colonel Gaddafi's regime made it quite clear that a prisoner transfer agreement could not be considered while any ongoing proceedings were extant. That was a matter of legal fact and was put to him.
David McCletchie.
Thank you, Presiding Officer. Mr MacAskill was absolutely right to begin his statement by saying that we should remember the victims of Lockerbie. But we should also reflect on the fact that the man convicted of their murder by a Scottish court has enjoyed 923 days of freedom, courtesy of the Scottish National Party, a remarkable period of survival for someone who apparently had only around 90 days to live. Now, the key allegation made in this book is, of course, that there was some kind of deal made between the Libyans and the Scottish Government whereby Megrahi would be released on compassionate grounds if he dropped his appeal. Interestingly, Presiding Officer, the allegation made in this book is, of course, the same allegation previously made by Christine Graham, MSP, who said that she had been told this very self-same thing by a whistleblower in the Scottish Executive. To that extent, of course, one allegation corroborates the other. Is it? Well, you may be contemptuous, Ms Cunningham, of your colleague, but I think she may have something to say later. Is it Mr MacAskill's position that both of them are in error and that these are figments of their excitable imaginations with not a shred of truth? And furthermore, the suspicion that Mr MacAskill took an unduly favourable view of the medical evidence to facilitate a deal would, of course, be allayed, Presiding Officer, if all the medical reports on which the 3 months to live assessment was made were released. The Scottish Government has consistently and conspicuously failed to do so. Does Mr MacAskill not recognise that the public interest and the questions surrounding the integrity of this decision-making process now demand that this evidence is released and made available for public scrutiny?
Cabinet Secretary.
Presiding Officer, there are two aspects here. One is whether there was any other factor involved in the release of Mr al-Megrahi other than my decision based on the criteria for compassionate release. The position is quite clearly no, there wasn't. As I made it clear in 2009, we did not consider any matters economic, political or diplomatic. That was despite the criticism and indeed what is quite clearly was ongoing by the United Kingdom Labour government that was openly conniving when Labour representatives were openly criticising me. Indeed, the same applied to the Conservatives. I can be quite clear to Mr McCletchie, we refused the suggestions from various Tory members. Let me remind him that Daniel Kaczynski, a Tory member, wrote to me on the 14th of August 2009 suggesting that Mr al-Megrahi should be used as a bargaining chip in negotiations. I refused that. Lord Trafalgar, a former Tory peer and a former Tory minister, on the 17th of July 2009, Lord Trafalgar wrote to me saying that speed is of the essence in returning Mr al-Megrahi back to Libya for reasons of business interests. I made it quite clear that we would not broker economic, political or diplomatic matters, and we made the decision subject to the laws and the values as I saw it of the people of Scotland. Let me deal with the second question.
Mr McCletchie, enough.
Let me deal with the second question relating to that of medical reports. Firstly, the only medical report upon which I saw and based my decision was that from Dr Fraser, the Director of Health and Social Care. That matter has been made available and doubtless you will have read it, Mr McCletchie. It is already in the public domain and has been so since September 2009. But you'll also be aware that matters of medical records are subject to common law confidentiality, and we are bound by that as we're bound by other legislation.
Christine Graham.
Thank you, Presiding Officer. I should first declare I am a member of the Justice for Megrahi campaign. I want to turn to the exact words of Abdelbaset al-Megrahi in the book at page 352 referred to by the Cabinet Secretary in his statement. With reference to the prisoner transfer arrangement, he says, and I quote, "For my family's sake, I decided I must choose the latter, that is, the prisoner transfer. On 23rd March 2009, I signed a provisional undertaking to abandon the appeal. That considerably predates any memos, Anything that's said in hearsay, these are direct words from Abdelbaset al-Megrahi. So it seems to me that instead of going on this wild goose chase now, we should be looking at having a full inquiry.
Do you have a question, Ms Graham?
Is it not the case, therefore, presiding officer, that we should have a full inquiry to all aspects of the Lockerbie atrocity for the sake not only of Abdelbaset al-Megrahi and his family, but more importantly, for the people of Lockerbie and the victims' families who still need the answers? And I would like to ask a supplementary to the Cabinet Secretary, has he had any indication of an inquiry from Westminster?
Can I say the position of myself has always been clear that I stand by the decision of the Scottish Court and upheld by the Scottish Appeal Court. It is for others to decide if they wish to seek to pursue matters through an appeal, as has been detailed, or indeed whether there is a request for a further inquiry. We've made it quite clear as a government that the restrictions upon our jurisdiction mean that any appeal or inquiry rather in Scotland would be limited. We would be subject to matters that are of a reserved competence and would either have to be done in terms of more than one inquiry or indeed in conjunction with the United Kingdom. We've said that we'll happily cooperate with any inquiry, but it would be for others to pursue that. And it comes back to the point I made it quite clear in my statement, presiding officer. It is not for me, and it never was for me, to decide how proceedings are carried out or not. I simply abide by the laws of Scotland.
Jenny Mara.
Presiding officer, it is clear that we need as much information in the public domain as possible surrounding this case. The Scottish Government has expressed a commitment to transparency through the Criminal Cases Punishment and Review Bill, and the Cabinet Secretary has stated today that data protection is a key obstacle to the disclosure of the Statement of Reasons under this Act. But in evidence to the Justice Committee on the 7th of February, the Assistant Information Commissioner said that the 1998 Data Protection Act did not prevent disclosure and that this Parliament has the power to define the conditions for processing by passing an Act allowing the Scottish Criminal Cases Review Commission to disclose. Last week, the Cabinet Secretary told the committee that the Information Commissioner had changed his mind. Will the Cabinet Secretary tell us the most recent opinion of the Information Commissioner on data protection and disclosure? And will he publish the correspondence between his office and the Information Commissioner between the 7th and the 21st of February in the interests of transparency?
Cabinet Secretary.
Well, we're always happy to publish whatever is necessary in the interest of transparency, and we do that. What I can't do is hypothecate what the current position is of the Information Commissioner, no more than it's in my control as to what the thoughts were or are of others, whether it's in terms of abandonment or indeed lodgement of further appeals. We'd have made it quite clear that we don't accept the information that was put forward by the Information Commissioner, that simply by making change to a subordinate piece of legislation that you can change matters that ultimately are part of primary legislation. You do require to take cognizance, even more so in subordinate legislation than in primary legislation, of the restrictions put upon you. And I did point out in our exchange in the committee, Ms Mara, that if it was so easy simply to do such matters within a subordinate legislation, then I and no doubt others in the Scottish Government would have made it quite clear that we were not going to enter into illegal wars, we were not going to impoverish the poor, we were not going to do a whole variety of other matters, if only life were so simple.
John Finney, to be followed by Graham Pearce.
Does the Cabinet Secretary agree there's an element of hypocrisy on the opposition benches calling for this inquiry when their colleagues down south have failed to disclose the UK Government's position?
Cabinet Secretary.
Well, it's for other governments, I think, to explain their actions throughout. I do think that there has been a great deal of hypocrisy. I mentioned that in particular with regard to Mr McCletchie, but it would be unfair of me and remiss not to remind Mr MacDonald and others in the Labour benches that they sat there and berated the decision of myself to release Mr al-Megrahi on compassionate grounds when the UK Labour government was conniving and conspiring to have Mr al-Megrahi returned to Libya, whether under compassionate grounds or under a provisional transfer arrangement. I cannot decide on the actions of other governments. I can only comment on the actions of myself and on other governments, and on this position we've been quite clear.
Graham Pearson, to be followed by Rod Campbell.
Will the Cabinet Secretary outline to Parliament the specific reasons he had for meeting al-Megrahi at Greenock Prison? And does he now recognise that his handling of that process helps in the minds of some to lend credence to the current controversy over the deal in respect of a subsequent withdrawal of Megahi, then imminent appeal. Will he publish all briefing papers leading up to that prison visit? And prior to the decision to liberate al-Megrahi on compassionate grounds, I understand negotiations and contacts were maintained between the Scottish Executive Civil Servants and representatives of the then Libyan government regarding Megrahi's release. Was there any conflict of interest given the other roles and responsibilities of civil servants? And again, will he publish the papers?
Cabinet Secretary.
Well, I think we've sought to publish everything that we can, except we are precluded either by medical confidentiality or indeed by the clear express wishes of other governments. The question that Mr Pearson adds was, why did I go to see Mr al-Megrahi in Greenock Prison? Let me be quite clear, I went to see him at his request. Why was that? Because I had to see him both on prisoner transfer and, I should clarify, also on compassionate ground application. But the primary matter was that he had submitted an application under the prisoner transfer agreement. As I pointed out, that was a matter that this government consistently opposed. There was a matter driven through by a Labour government down in Westminster. It applied to only one prisoner in Scotland that we've ever possessed who have been of a Libyan nationality. And it was quite clear when they entered into the prisoner transfer agreement that it related to Mr al-Megrahi. Our requests to have him excluded and specifically taken out of the agreement were refused by the UK government. But this agreement, the prisoner transfer arrangement here, was different from others, in that this one, an application could be submitted not just by the individual, but by the government concerned. The government concerned had submitted the application. It was the Libyans who submitted the application, and I required to make sure that the prisoner had an opportunity to be heard, because there could be examples or scenarios where an application could be made for a transfer of government, but an individual would not wish that to be dealt with. I offered Mr al-Megrahi the opportunity to make representations and to be heard. He requested the right to make those representations. He wished to make them formally to me, and I accordingly went to see him in Greenock Prison. So I did so because of the legislation brought in by the UK government that required me to take into account his views on an application on his transfer back to Libya. More importantly, I should point out that had I refused to go, then the likelihood is I would have faced being judicially reviewed by his legal team.
We have very little time to conclude the questions on this statement. Mr McCletchie, if you would please keep quiet. We have very little time to conclude this. Can I remind members that you should ask one question? Don't do a preamble, and in that way I may be able to get as many people in who have requested to speak. Rod Campbell.
Thank you, Presiding Officer. Cabinet Secretary, would Mr al-Megrahi have been granted compassionate release if he had continued his appeal?
Cabinet Secretary.
Yes. Prisoner transfer required an end to an appeal in terms of prisoner transfer agreement. No such requirement was required for compassionate grounds. The criteria for compassionate grounds were the evidence put before me from the Parole Board, the Prison Governor and the Director of Health and Social Care. That application would have been granted.
Alison McInnes, to be followed by Colin Keir.
Thank you, Presiding Officer. Can the Cabinet Secretary tell me if the present Lord Advocate has personally assessed the allegations made against the Crown Office for obstruction and cover-up of evidence reported in the book, and has that assessment been shared with the Cabinet?
Cabinet Secretary.
Well, matters in charge in respect to the Crown Office are for the Lord Advocate. I have had discussions because I'm aware the Lord Advocate has made it clear that this is an ongoing inquiry. Nobody has ever suggested that Mr al-Megrahi acted alone. It is for that reason that matters are ongoing with inquiries through the Crown Office and by Scottish Police. I don't think it would be appropriate or correct for me to comment on any other matters other than to say I have the utmost faith in the Lord Advocate.
Colin Keir, followed by Eileen Mudd.
Thank you, Presiding Officer. Can I ask the Cabinet Secretary if the Scottish Government could require the SCCRC to publish a statement of reasons in circumstances where an appeal has been abandoned?
Cabinet Secretary.
No, we can't require the statement of reasons to be published. What we can do is provide a framework within which the Commission can put forward those statements of reasons. We initially tried it through the subordinate legislation route. consent was not coming from a variety of matters. They requested additional powers. It is for that reason that I am bringing forward this bill that will allow them to have a framework to consider a variety of matters, such as Official Secrets Acts, human rights considerations. But as I say, the whole action of this government is predicated on allowing the Commission to be in a position to publish.
Liam Murray, followed by Hamza Youssef.
Thank you, Presiding Officer. On behalf of my constituents in Lockerbie and all the friends and relatives of those who died on the ground and in the air, can I ask the Cabinet Secretary to give his assurance today, to give his word that neither he nor anyone connected with the Scottish Government or Scottish Court Service at any time put pressure on Mr al-Megrahi, his legal team or the Libyan delegation with regard to the withdrawal of his second appeal?
Cabinet Secretary.
Absolutely.
Hamza Youssef.
As the Cabinet Secretary has mentioned, there is a bill making its way through Parliament which will add further transparency to this issue. On that note, can the Cabinet Secretary confirm if Mr al-Megrahi has or has not consented to the statement of reasons being released?
Cabinet Secretary.
My understanding is that Mr al-Megrahi has not consented to release, which is one of the reasons that we are requiring to proceed with the bill.
Final question, Malcolm Chisholm.
Is the Cabinet Secretary suggesting that the UK government has a veto on the publication of any report from the Commission because of the reservation of data protection?
Cabinet Secretary.
Well, no, it's not for me to be responsible for what the Commission publish, but it is quite clear that data protection is likely to be a significant impediment. It is for that reason that I entered into discussions with Kenneth Clarke, and as I've said on other occasions in this chamber, I've been grateful for him considering matters in the spirit in which he has done so. But I do think that over recent days, with both books appearing and indeed documentaries forthcoming, it is important that we have a balanced position out there, and it's important, therefore, that the Statement of Reasons is published. All I can do is provide a framework that hopefully will allow the Commission to be in that position, but it's for them to make that decision once they've considered all the criteria that are set down in the bill.